The court, having had an opportunity to review the temporary restraining order as well as the memorandum in opposition and a number of the declarations, I reviewed the declarations from this morning. I'm sorry I haven't had a chance to review the declarations that were filed during the lunch period. However, the court, also having had an opportunity to listen to the arguments of counsel, the court is ready to rule. First of all, the court does find that the plaintiff failed to exhaust their administrative remedies as required by law. Secondly, regarding plaintiff Namakua Omawi, the court finds that the complaint contains no allegations regarding Namakua Omawi's legal status, members, purpose, or geographic location. It is clear to the court that in the absence of an enabling statute, an unincorporated association cannot sue or be sued in its common or associate name. Therefore, the court does find, as far as plaintiff Namakua Omawi is concerned, they do lack legal capacity to sue. Secondly, in regards to plaintiff Mr. Dansel, it appears to the court as well that neither the complaint nor the TRO establishes that Mr. Dansel has standing. Mr. Dansel himself must establish that he himself is being harmed. He must allege injuries to himself, and he has not done so. At the very least, Mr. Dansel cannot establish that he has met the third prong of the Sierra Club case, namely that a favorable decision is likely to provide relief for his injury. That being so, the court finds that plaintiff Dansel lacks standing as well. Therefore, because Namakua Omawi lacks the legal capacity to sue, and plaintiff Dansel fails to allege concrete facts sufficient to give him standing, the court does not have jurisdiction over these claims. Even if the court did have jurisdiction, the court finds that the plaintiffs have not demonstrated that they are entitled to injunctive relief. The complaint does not state claims upon which relief may be granted. Therefore, plaintiffs cannot establish any likelihood of success on the merits. Also, in balancing all of the equities, the scales do tip very heavily in favor of the defendants. Canceling this event will not prevent the harm suggested by the plaintiffs, but will irreparably harm members of the Lahaina community. The court did have a chance to review this morning's 10 or so declarations that were submitted to the court from merchants, restaurant owners, hotel people, all from the Lahaina area. And it's clear to the court that they do depend heavily upon the revenue generated by this Halloween event on October 31st. Therefore, the court hereby dissolves the temporary injunction restraining order that was entered on October 25th, 2011. I'm going to ask Ms. Lovell to please prepare the findings of fact, conclusions of law, the order as well. I'd like to sign it before Halloween, so if there's any way that can be delivered to the court promptly, I would really appreciate it. Thank you very much, Counsel.
Your Honor, for the record, I take exception to your ruling, and for purposes of appeal, we set forth our objection for the record.
Thank you very much.
All rise. Court is adjourned.